very long day, and this morning we will speak about digital markets of the future. My name is Maxim Proksh. I work in the Skolkovo Foundation. We work in the issues of intellectual property, the future of intellectual property, the development of IP institutions, influence of technologies, and new technological environment on this sphere. And yesterday's discussion showed that the world is changing very fast and greatly around us, and the reality which we are used to, which used to be very clear and available for us, is changing as well. I'm talking about analogous classical reality with fundamental understandable rights, with clear right holders, with everything was understood. If you want to listen to music, you have to take a CD or a record. If you want to see a movie, you take a video cassette, etc. If you want to buy shoes, for example, you have to go to the shoe store. But now things are a bit different. If you want to get access to music or movies, you have to press just one button in your device, in your smartphone or TV. And if you want to buy a pair of shoes, you have to print out a CAD file in 3D printer, so you have your shoes. And even movement of goods, I believe, will be in the past, and everything will be personified within. We have a program of digital economy which is very actively promoted nowadays by our government. There is a focus on personal consumption, personal markets, personalization in general, and here we have a question: what will happen in the field of intellectual rights? Will we have personal management of rights? Will our relations change? How will change the access to the product? And how will the lift from initial rights holder to the final right owner change? Will we need some intermediate things which will help us? And how technologies will influence on all these things? I believe that it will be very useful for us to discuss all these things, because if we do not understand where we are moving to, we might stay in our paradigm and our mentality, but the world will move forward, but we will stay in the place where we are now. That's why I have outlined some topics I would like us to discuss. So, dear speakers, let us start. And I think I will give the floor now to Elena. That's because yesterday we had quite an interesting session on personal data. And as you can see, we are discussing issues not only of IP, but related issues as well. And today I would like to speak about connection of intellectual property with big data, with artificial intelligence, and to show how these new technologies influence our field. So, Lena, where are we moving to?
So I hope, as usual, we are moving towards a better future, towards peace in the world. Speaking about digital economy, so we have to admit that the first steps have already been made towards the fourth industrial revolution based on the digitalization of our economy. Today we have all the necessary tools that will allow us to shape the future, its color, its movement, its smells, its movements and shifts and other characteristics. So everything depends on digitalization. So it has become fashionable today to say big data. It has become a buzzword. What is big data? Big data means information, and information cannot fuel anything as such. Information has to be processed, has to be used in one way or another. And today we have more questions than answers to them. So we cannot differentiate what is raw data, raw intellectual material, whether they are part of big data databases, or this is just information as such, freely flowing like air, that belongs to everybody. We don't know whether we should start discussing the ownership of this big data. For instance, how do we interpret a flow of data from CCTV? Who owns this data? And who owns the data, for instance, that we feed in ourselves when we chat on the social media? Many researchers say that we have to work on a new digital economy legislation. I am a conservative lawyer. Conservatively minded lawyer, and I think that the federal legislation has already answered all the relevant questions. I understand that the digital era has its own specificities, but it does not require the introduction of a completely new type of legislation. So I guess that we have to go into detail. We have to understand the very nature of some phenomena of the digital economy and learn how to adjust the existing legal norms to the changing reality, so that the law fits the changing reality. Of course, another problem is, as in a matrix, not where we are, but when something happens. Translated to who or what. So we are using AE, abbreviation, artificial intelligence, abbreviation, all the time, but we don't understand what artificial intelligence is, how it is interpreted, when it will be invented. This is a software, a design software designed by people for other people. And when we ask ourselves whether AE, artificial intelligence, is a subject or an object of law, so I think that we are running faster than the locomotive. So we have to stop and think. I don't think that an android, even looking like a human being, I don't think that this android has to be considered a subject, a person. From my mind, a machine, a robot, an android will never be treated as a human being. I understand that the capacity of calculations of an android is higher than people. Robots play chess better than human beings, but it doesn't mean that androids have to substitute people. We create them not to substitute us, but to assist us. And that's why when we start discussing us being unjust to androids, and when we start discussing seriously a case when androids or some software programs will help, for instance, resolve court cases, I don't think this is the right approach. If we don't want machines to substitute us, we have to adjust our legislation and exclude the very opportunity of androids or software programs becoming subjects. And of course, there are many theories, including the fiction theory. There is no such a subject of legislation. Androids or artificial intelligence, I think, will never become subjects of legislation. They may become subjects of legislation only when we understand properly what artificial intelligence is. Today we are speaking about emerging borders between various norms of the existing legislation that actually leads to some sort of a confusion between the subject of law and an object of law. But at the same time, the world is not ready to continue being in two minds, changing one illusion for another one. And I don't think this is the right solution. So the main legal task that we have to focus on is not only to perfect the existing legislation, but also to create ethic norms of the introduction of artificial intelligence into our everyday life, especially in the sectors that are related to our well-being, to healthcare, and to our judicial system. Thank you.
Thank you. A machine has written a song, a good song, and everybody likes it. And who is to be paid for this song? What do you think? Well, I like robots. I adore robots. And I think and probably that's the evolutionary advantage that the human can get, one of the instruments of perfecting a human. And now legislation goes two ways. So the rights can belong either to the developer who created the machine, or the rights go to public if it's an open license. So the libraries which we use in developing process, they are open license, and the code which is written on the background is becomes the public advantage. So now the industry is developed by fans, those people who are excited about robots and see the advantage of robots, and they believe that it's a new stage in human development, and that's why the majority of libraries is the production of data set, and these neural networks are in the open public access. And now it is facilitated by the corporation, and of course the soft that they have created is the priority soft. And now the intellectual production, which is created by decompilation. So the rights on this product belong to the developer as the result of processing, and it is known as the minor creation. So these elements are derivatives from the big elements from the big machine which created that. So I think that the robot will write in a song in Russia, so the rights will develop to the will belong to the developer. But if the robot will write the song in the United States, then you will have to consult the legislation. I think that in terms of the future development, that's more about technologies, and we work with the transfer of technologies, and we see that the market changes. So we need the code, we need the data. We don't need the code, we need the database. We don't need the database, we need the technology and how to create the database, how to set up the database. And now we come to understanding that the major question is, how can I solve the problem? And the market will be happy with any answer. So the developers of IP can choose any regime which will satisfy the demands of the market, depending on the jurisdiction which will use the technology. So we see the digital market as the market of technologies. And thank you. And this new market of technologies, will it have some space for the creativity? Yes, certainly. And how is the technology made? I'm sure that everything in humanity, in this world, has been created by the intellect. So first you have got an idea. Idea occurs to somebody, and then it instigates the creative power. And this creative power comes not only to the artists, but to the researchers as well. The researchers need the creative potential to develop a new idea. And unlike, the ordinary understanding of creativity, researchers spend much time and effort to test the hypothesis, to validate the research. But it's a creative process, the same as many others. Vadim, what do you think of that? I would like to comment on that.
We heard such a notion as a robot, artificial intelligence, but we have to understand that there is no artificial intelligence by itself. Robots or androids do not write music just like this. This is a program code which has been trained by big data massives. I have a question. Do we have to pay license fees for the content on which this artificial intelligence was trained? This is the first thing. And the second thing, just imagine that artificial intelligence has written a large amount of music, and the next version of the artificial intelligence is not written by it. So in this case, who will have the rights and what do we have to pay for? So really, we develop this topic or go further in this topic, then we will not understand how to differentiate between the objects. I mean, in terms of legislation, we will not differentiate between the objects written or composed by human beings or by androids, because these are separate things, and these objects have and there might be some confusion in the market. Here we have two variants. Either we have the case of adjacent rights or related rights. Some of them belong to the owner or creator of these algorithm, and part of them belong to those who create this content. This is one of the variants available. Or if the rights, it's the same way as when we grow children, we buy books for him or her. The same, it's for artificial intelligence. We have to pay for the content, train it on this content, and then all the rights will belong to the right holder of this content. That's very interesting. Valeriya. We have looked into the future. As for the present day, how do the existing technologies, modern technologies, help us to pay fees or bonuses to the right holder? Do we have our national experience in this field? Thank you for the question, Maxim. Good morning, everyone. I'd like to say that we are in a very interesting period of time, and we are living in a very interesting period of time. We discuss such things as artificial intelligence and, for example, music. Does a human being own the rights, or the artificial intelligence own the rights? Nowadays, it's very important. It is written in the strategy of innovation development. The president says about this in his address to the Federal Assembly. But we actually need the technologies to solve the problems on the market. We have a lot of such problems. This is the crisis of confidence, which these are. This is an absolutely crazy procedure of confirming the right of the copyright. We know that people who have copyright do different things to obtain this copyright. So the mechanisms of digital platform are needed to protect the ideas before patents, to protect the ideas before they are published. When a person has some idea in his head, for these we need digital platforms. And this is the tool which helps us to create the infrastructure where right holders and the users can meet, can make deals, and to commercialize the results of their work. So this is where can they meet by themselves. We all are talking about digital platforms, digital services, the environment of confidence or trust. Artem, I would like to understand that from the technical point of view. We have always had different registers or ledgers. We had different objects there, but we are not talking about the blockchain technology. This topic is constantly being discussed. Clever people, so to say that blockchain technology is not needed everywhere. But from the point of view of different transactions with the results of intellectual property, why do we need this blockchain technology? Why can't we register them just in a ledger? Can you give a comment?
Good morning, everybody. I'm very happy to see all of you here this morning. So when it comes to hype and blockchain technology, blockchain-based solutions, first of all, I would like to remind all of us about Bitcoin and cryptocurrency. Bitcoin currency, when many people started making money, getting profits on some sort of transactions. But speaking about transactions on the internet, direct transactions between different subjects, actors of this network, the industry managed to develop a breakthrough technology which is used not only for financial transactions, but it is used for the building up of corporate business networks in cases when participants or members of the network do not trust each other, and for one reason or another. So that's why business started using IP chain, the IP chain technology, and the IP chain based register or ledger is a very reliable registry that allows us to store data and it protects the data from being changed by any participant of this network. So it's a trustworthy technological solution. The blockchain technology as such is a useful technology. It is used in open platforms, on open platforms, or closed blockchain-based platforms similar to IP chain, which is closed in its character, and it is based on very reliable encryption mechanisms, and there are methods of consensus that does not require any considerable resources, but it allows us to solve the famous problem of Byzantine generals. The generals who did not believe each other, did not trust each other, but then they had to negotiate how to attack a a territory, an enemy territory or an enemy state. So this is just a metaphor. So to cut a long story short, blockchain is a very reliable resource, a very reliable mechanism for storing data that everybody trusts and everybody believes. Thank you. I would like just to continue what you said, our discussion, and now I would like to ask Mr. Fokan. Do you think you could share your experience of using the blockchain technology? This is question number one. And question two, I would address to other participants. Blockchain guarantees the unchanged volume of the stored information. Who can guarantee that this information has been placed on the blockchain platform of a trustworthy person who has the rights to download, to post this information?
Actually, as my colleague said, blockchain is a distributed ledger, and it provides this Bitcoin protocols, Ethereum protocols. It provides to timestamp the data and protect the data. But let's remember, we are in digital age now. We are collecting and broadcasting our data with the HTTPS methods. I mean, the data is going to server and coming back from the server. And in this kind of cases, as we have seen, there's a hacking issue. It happens. But in the blockchain, yes, there's a possibility to hack, but it's something like looking for a small thing on like 1,000 metacores. It's not that easy. Nowadays, it's easier. That's why blockchain is not easily hackable. And also, when you send the data, you have to, for example, if the data is in the node C, you have to know node A, because the instruction is coming from there. That's why blockchain is really securable place and atmosphere for the topic that we talk. I mean, artificial intelligence we talk with robotic issues, how we implement to our daily lives. But first, we have to find a way to protect our intellectual property rights, because everything starts with it. Just imagine you are in the frozen age and you find a stone and you write to wall something. That's the intellectual property right. By looking at, actually, we have progressed as a human being. I mean, how we progress is somebody came, look at the wall and made another comment, and now we are using a Latin language, or we are using, Kirill language. It progress with this kind of way. That's why blockchain is very secure and that we need to progress to move on.
У вас еще какой-то ролик был? Вы потом его...
So you have also got some video material. Are you going to show it later or now?
If you want, I can show it right now, the PowerPoint.
Если вас не затруднит. Покажи.
So if it's not a big problem, we can see it right now.
Let me tell you about for myself. My name is Furkan Köseler, and I am the Vice President and Board Member of Blockchain Eurasia Association. Now I will make you a presentation how we can defend intellectual property right, and what basically blockchain is, and what's the possibility of applying to some industries. I hope you enjoy and you understand what I'm trying to explain. Thank you. Blockchain Association of Eurasia, we aim to progress blockchain. We aim to explain what blockchain is and what's the possibility of appliance to some industries. Basically, blockchain is a Bitcoin protocol and Ethereum protocol, and in some progression it goes on. As you have seen, there are some sectors that I give importance. Intellectual property, smart homes, which is general, and renewable energy also. Three main benefits of blockchain technology, as you have known or as you have seen: cost reducing. I mean, you can easily connect. And nowadays, in e-commerce issue, when you look at, I would like to give you an example. 1 year ago in United States, there was an airlines and insurance company. A customer said, "I don't want to get in my flights, and I want to get my price that I paid back." And how do they realize it? They give his or her money back by blockchain technology. In a second they did, and it gives the easily connected issue to humankind. And also point of service process accelerator, I have written it down. Just imagine you are in the store and you don't want to wait in a queue. And if you live this experience, how do you feel? You say, "Oh, everything is so easy, everything's super fast, and okay, I made my shopping and I'm happy about it." And I think in the closest future we will see that. And in addition to this, data usage saving. Nowadays we use enormously data, and some of them is waste of data. Actually, 2 weeks ago, I have read and studied an article. It was including e-waste. I mean, imagine 20 to 25 years, maybe 30 years, as a humankind, we are producing hard disks, laptops, and right now we are not able to use the old technology. So this is it's really bad for our service. It's another trash that we created that we couldn't use it. That's why we need blockchain. And as a note, I have tried to explain now we are living the industrialization 3.0, and when blockchain is fully understandable, we will see the industrialization 4.0, and it includes artificial intelligence, and it includes not fully robotic life, but partially we will see some robotic life in our daily routine. And these benefits will evaluate Web 2.0 to Web 3.0, and I will talk about later. And let's go another slide. As I try to explain what the blockchain is, blockchain basically distributed ledger technology. Everyone has separate database. Each keeps data separately, centralized, deniable. Right now, that's our modern life. And also, everyone has the same distributed ledger database. Keep data in a single block, secure, distribute, peer-to-peer. This is the revolutionary changing in our life, for our life. And for the next slide, we see use of blockchain in intellectual property. There are some problematic approach that we live nowadays. Registration, tracking, asset transfer, worldwide payment database, peer-to-peer payments in real time to intellectual property owners, and also smart contracts. It's really important progress for our service. So rights management, distribution of liability, and all other intellectual property contracts. And By explaining that, I would like to show you in our current system in trademark and patent sector right now, and what blockchain can do that. In the registration, each keeps registration and all other data separately in our current system. The data, they are not speaking each other. And in the blockchain, keep registration and all other data in a single block. In this way, node A to node B, node C, we can easily speak with the data to each other. And as you have seen in security risks, which I give huge importance to this issue for nowadays, for the blockchain, secure, distributed ledger technology, and it gives the full security to ourselves. We feel secure, and also distribution and payment, real-time smart contracts, real-time peer-to-peer payments, and cost-effective. It's our current system. It seems it's dysfunctional right now because we are not basically protecting our international intellectual property rights. And if we are not protecting, how can we aim to progress? Because, for example, I discover or I made a patent something, but I need a missing part which somebody discovered. I have to see, I have to understand, or she or he has to understand my discovery, and in this way we can progress very fast, very speedily. But we have to make it record, and we have to make it less payment, because if we cannot give it reachable market, reachable atmosphere, we will not speed up. We will live like this, from my point of view. It continues, as you have seen. Just please come back. I would like to explain this data, which I give importance also. This is copyright issue. It's our current system. It's blockchain. Actually, every intellectual property right begins with the copyright, and then it continues depend on the progression, trademark, and patent. That's why we need data, and we need to record it to progress this market and this issue. And which blockchain protocol, legal, stability, future, these are the answers, but which blockchain protocol, I think it doesn't matter, it shouldn't be matter. And also, I would like to show some video to you, which is the study case. I think now you will understand what I'm talking about. Let's see, international awards winning use case, proof stack, formally comparable, listen it.
People around the world create some amazing stuff, and then they share their copyrighted work with thousands of other people. But how can you protect your work internationally? As laws and regulations differ from country to country, international copyright law does not exist. This gives way to an increased infringement rate as creators face huge challenges while practicing legal actions in other countries. And using local proofs in foreign courts takes some time and costs a lot of money. Introducing CopyRobo, world's first company that uses both blockchain and qualified timestamps to provide local and global legal proofs. Various countries have started approving the use of blockchain and cryptocurrencies. That eliminates the need of third-party involvement. Whereas with the new EU regulation in place, EU qualified timestamp proof is legally binding and is recognized in 28 European countries. With CopyRobo apps, create private or public proof for your file and secure your rights in just seconds. For a private proof, simply select your file location, pick a timestamp, and click on the preferred location to store your proof. Your private proof and private link is ready for your protection. A combination of a time-stamped digital file, hash value, and a unique URL. Public proof is a timestamp file that includes thousands of hashes that belongs to CopyRobo users, allowing millions of people to use the same legal proofs. So choose the right public proof anytime for your cost, speed, or any other purposes. Reduce infringement and cut down copyright costs with CopyRobo. Keep creating and keep sharing.
Now, as you have seen, CopyRobo.
И как вы видите, копироба.
Спасибо.
If possible, can I you have seen CopyRobo presentation. Now we are proof stack. We moved our company to Singapore. I would like to ask all of them, please download the proof stack. You will understand what a digital application can provide by using blockchain technology. Now it's available. I think by downloading and by using, you will understand what I'm talking about the blockchain. And thank you very much for listening to me. We should have a great week. Okay. Thank you.
Thank you very much. That was a very interesting presentation because I'm impressed very much that in different jurisdictions, facts fixed in blockchains are recognized. It is very important, I believe, that courts of justice would recognize the fixation of legally important or significant facts in the blockchain. Elena, what do you think? Will Russian courts will get to this, and will they ever get to this? Otherwise, the system needs not to be developed. Of course, they will get to this. The progress is not in one place. 10 years ago, we could not even imagine the electronic systems of registration. Now we have the electronic system of legal issues. If we use the database in the blockchain, the problem is that the courts cannot take this information from blockchain because they are not trusted nodes of the system, or they are not constant users of the system. The question is how this information is to be presented. Nowadays, in many countries, for example, in the United States, in the UK, the information received from blockchains is confirmed by the conclusion of an expert, which confirms the fact of a deal, and he confirms authenticity of this information contained in the network. There is no country in the world nowadays which accepts proof or evidence in digital format from blockchains. So I believe as soon as we have the first legal cases in Russia, we will have to go through this way. We will have to go this way. The first, when we have the first conclusions of experts. I hope that the Court on Intellectual Rights will get access to this system, including the IP chain system, and probably this practice of cooperation will enable us to make this experiment, which will open the door to this field for all the courts. And I believe that in this respect, we will be the leaders or front runners in the world. Of course, we have to be front runners in some things. I would like to add that we have a stable legal practice on accepting evidence for deponing, and it really works. The main task of a blockchain is to establish a unified standard of the system for people who work in deponing could work. So we actually had some cases, court cases, but without blockchain. But the documents of deponing are accepted by legal courts, and in this case, blockchain can be the instrument which does not doubt that this document. And I believe I don't see any obstacles for the court to analyze this evidence or proofs. And the Supreme Court actually confirmed that courts of justice can use any kind of proofs, including electronic correspondence. So I believe that a site which has a proof about deponing or any other document can have a document with a hash or blockchain, and which has the certificate this concrete deal is authentic, can be used as a proof. We are all under Berlin Convention, and it covers more than 160 countries. And according to this convention, the author who has received protection in his own country can be protected in all other countries, or can count on protection in other countries if you have the technology available in each country, and if there is a system which enables authors to prove that their authors, these are deponing certificates or any kind of any other document confirming their copyright, they can count upon legal protection in all these countries. And blockchain can be of great assistance in this case, because it can be the basic standard which is much easier to develop than to change legislation in each particular country. Let us hope that one day we will get to this situation when a fixed fact will be taken as a evidence and proof in courts of justice.
So I would like to add a few words. Of course, there are lots of hypes around the blockchain technology, and blockchain is a magic word that increases capitalization. And apart from it, blockchain is just one. Let's be frank. So it's just another variant of digital signature. Digital signature testifying the ownership rights, so to say. So in this situation, we have to speak about the owner of the technology and how the owner of this technology is responsible for the exact character of the data it holds true just in the same way as we defend the rights of our ownership right. For instance, if we write a book, or if we, for instance, post our creative work on YouTube or elsewhere. So when you offer something as a proof of your ownership with the mentioning of the date of publication, and then all of a sudden another person contacts legal authorities, and he says that I don't know what was published and when it was uploaded. I was the first to publish it, to make it published. And if this person posted his information on this blockchain platform, that the ownership right will, belongs to him. So yes, but I still have a question. I have my own concerns. For instance, if we place some objects on the blockchain platforms, and then for one reason or another, a legal person who provides for the functioning of this blockchain, something happens to him. I don't know what or why, and then nobody. Does it mean that nobody will be responsible for this blockchain platform? What will happen to its subjects, its players? How can we guarantee the protection of the data if this person who is responsible for managing it is absent? So I would like to say a few more words about the blockchain platforms. Now we are testing the National Register of Intellectual Property, IP National Register or Ledger. This is also based on the IP chain technology, and we have our own ecosystem that allows us or IP right owners to deposit their IP property, to have a certificate of ownership, and to have a reference, a hash reference to hash. And just to continue the story further, whether we can trust this digital signature, the nodes of this IP chain are big public companies, large-scale public companies, for instance, Rospatent, FIPS, and other large players of the national economy. And since IP chain is a protected chain and we have state actors, IP chain itself is a distributed platform being part of the national economy. That means automatically that the state supports this idea, supports this economy. And of course, I am sure that the distributed character of this platform actually offers all the necessary protection of information and of digital signature and ownership rights. So now going back to your question, what happens if the manager of this blockchain platform disappears? Well, as far as I know, there have been tests of this distributed register, and even if the disappearance of one node, of one element of this blockchain platform disappears, nothing happens to the chain itself. So the chain is sustainable. It's sustainable, it's protected, and it's very trustworthy. So it's safe to use it. And I would like to stress the idea that this is a new ecosystem that already exists. The system is there, it is tested, it is further tested, it is further perfected, and maybe Valeriy, when he takes the floor, will tell you more about these tests of blockchain platforms. And if we think about artificial intelligence, it's another story. Neuron-based networks. It's a completely new story. So our task is to provide the unique character of the subjects and fix IP rights. So we have to find similar objects to compare new IAE creation with. So we're working on the algorithms of identification of authenticity of, for instance, music, melodies, and compare it with some reference patterns. Neural networks can be taught how to do it. And when we started our first experiments, we realized one problem, that there is one problem. For instance, the training of engineers capable of solving the task of identifying the authenticity of a melody. How to teach neural networks, and who are the specialists who are going to teach neural networks to identify the authenticity and define the IP rights. There are lots of specialists working on the market who are involved in AE technologies in one way or another, but still there are tasks that these specialists cannot actually resolve, and maybe we have to work together with the Ministry of Education, training specialists who will be capable of solving similar tasks, capable of working with big data. So this is another challenge. So if among participants of our IPQuorum there are representatives of higher education institutions, if you have any ideas of how to train specialists filling in the gap on the market, then you are welcome to contact me. Thank you.
First, I would like to remind that I will leave about 10 minutes for the floor to come up with your questions. So if you have any questions, think about them, and we will try to answer them at the end of the session. So, but I have got some more questions from myself. If we get back to the artificial intelligence we have got chatbots, we have got some elements of the agreement constructions and so on. Yeah. So Irina, the question to you: you are as a lawyer by your background. Do you feel any danger that the artificial intelligence or machine will very soon represent a serious competitor who can work 24 hours a day, who doesn't have to stop for eating or, just break to have some rest? Don't you think that it will be a problem? Well, yes, so the machine can work without food or water, but it cannot work without electricity. So yes, there is a tendency to think that the lawyers can be replaced with robots, and we remember the famous case with Sberbank. But I cannot think that we can introduce some digital legislation or digital judicial system, because there is a simple example which very often is referred to at some legal forums and so on. So if when a person drives and the camera video camera records him violating some rights, so then the electronic legislation will write out a fine, but if there is a judge instead of this electronic legislation, he can take up some explanations about the particular situation, reference to, just the context of the particular situation. So if we move to the robotics to electronic legislation, I don't feel any competition, because I think that there are so many special things, special features about this legislation, electronic legislation, that I don't worry about that. And even if we think about that, so there must be some lawyer who can teach robots just what to do in different cases. Yeah, so I think it won't be very soon. Well, who teaches robot to take the decisions, to make the solutions? Well, and then who is going to be paid for teaching robot doing something? So probably I'm ready to retire if I can be paid for what I will teach robot. So, when we think about these new technologies, of course, they all have advantages and disadvantages. Advantages, of course, we have first to regulate this space very much. So we have to work out some certain terminology. And you understand that if technology is not advanced, so it will die very soon. And we see that if the technology is moving on, it means that it incorporates all the advances and all the benefits of our own development. So we will have to guide the technology into the future, thinking about the laws and thinking about what we need from the technology. And there are some testing grounds nowadays where we can organize a forum speaking about what we want to see from the technology in future. We can involve more experts who can express their opinion about the future and what we will see in the future. So that's very nice to hear from you. And Andrei, when do you think IP chain will become more powerful? So what's the idea? Why do you ask it? Well, I think that so far IP chain database will use ICO, if I'm not mistaken, in May this year, and it is going to get about 5 million euros. So I think that the only thing that can interfere with these plans is the judicial legal case with IP chain trademark, because IP chain trademark now is kind of inherited from the German predecessor. So, and now it is using the same trademark, and the trademark you can see on Artem's T-shirt. So yes, you know it's a kind of our trademark, and we have got so many followers that probably, and so many of those who wish to inherit our sign, our trademark, that so probably it just tells about the popularity of the topic. Well, but you know that this development of this issue lets you use your individual rights. So if you go on thinking about the user, you can track the user, and you can track all the individual features of the user. Doesn't mean that the collective use is over. So that's what I would like to show you. No, probably, yes, probably we can say that the time of the collective management is almost over in the form that it exists now. I think that just we can formulate the problem differently, or we can word the problem differently. Now we see the authorless, the problem of authorless creations. And, just you see that now the technology is such that it's much easier to use the technology if you are an individual. But if you're a collective, that's a little bit much more difficult. When it comes to those who create something but then doesn't do anything about their creation, that becomes a problem. So then it means that this co-management society can regulate this aspect. I see Anatoly Semenov here in the room, and he is the supporter of the idea of transferring to risk management instead of right management. And I think that this authorless, product authorless creation can become the issue for this new type of management.
So you mean to say that all those who are actively involved in economy and want to manage their rights by themselves or copyright by themselves, they will have a range of opportunities, but collective management will be left for those who do not need anything. That's right. Okay, colleagues, we have 10 minutes now. Let's answer questions. Can I give a comment on this? I to some extent share this point of view about the death of collective management, so to say. But I would like to say that I'm one of the developers and owners of the system of licensed rights. I manage the MediRise Revolution, we call our product. So we've been on this market, in this market for quite a long time, but automatization of the companies who are the major right holders is very big. And I want to say that the idea of self-governance of their rights or self-management of their rights, which are which the authors say about, so they do not find if I have a chance to show my presentation, I will show what a typical contract is and how the money are distributed. This is quite a big mathematical draft which shows how money are distributed in licensing contract, and these conditions as for each contract should be tuned by the right holder. Now, show me a single author who would spend weeks for training, and in case of smart contracts and blockchain, for studying programming and making the scheme of money distribution for each concrete contract. I'm sure they will not do that for sure. There are no such authors, absolutely. But there are developers of these systems, as you are, and as soon as the developers or programmers as you will come to simplified solutions for the authors, then the authors will be very happy to have this. We may speak about your own experience, but probably you should work with the people who are in this market. We had a survey and asked the people what they think about this new technologies and blockchain, and the result of the survey was that about 5% of people people were not aware of this, but most of them wanted to use these technologies. So we need to give them an interface for them to be able to use it. Look, the main problem here is that authors will choose a simple scheme. Now we are talking about digital rights. But most of the licensed contracts and the colleagues from industry know that these contracts are between incoming and outgoing contracts. The number of contracts. So these contracts are much more complicated than a simple author copyright scheme. So when the scheme is very much complicated, so to make such a smart contract is not easy, so to say. And the situation is as follows. Finally, the community on managing copyrights will probably turn into something, but I believe that the market will be kind of place. There will be agents who understand the situation, who can manage some other people's rights, and probably these agents should not be authorized by the state. These are people who have special knowledge, who have special qualification, who can manage finance, who can manage this financial things. This is the scheme will be understandable for all players in the market, and this scheme will bring much more to the industry than the existing situation with getting signature. So, you mean that one professional mediators will be substituted with the other professional mediators? Yes, I think so.
So, colleagues, Q&A session. I would like to ask you to introduce yourself first, and please speak to the microphone.
Здравствуйте, уважаемые коллеги. Спасибо за...
Good morning, ladies and gentlemen. Thank you very much for such an interesting discussion at the forum. I represent a non-profit organization of IP rights holders. So we work with companies, and we accumulate IP rights and place them on digital platforms, and we provide legal protection of the information on the internet. It's impossible to work nowadays without offering protection to your content. No matter how good your scenario is, no matter how good the song is, still any producer has to invest into the protection of your IP products. So when we protect our concrete IP products, for instance, a movie, a protected product earned $250,000 US, generated $250,000 US dollars more profit compared to a non-protected one. So I know that my colleagues are working on a platform that will be able to to offer even a better protection of intellectual property rights. And I would like to wish all of us success in this very difficult business of protecting virtual content on the internet. Thank you. Anybody else who has a question, please introduce yourself. Good afternoon. My name is Elina, the Russian Institute of Economics and Law. This is a very interesting topic, and such platforms are needed. It goes without saying, but how will it influence the number of transactions and IP contracts? Will it influence it or not? And I have another question. So from the point of view of patent analysis, the export VAT profit tax on IP is 20% only. And if we compare this percentage with other countries, then the interest rate is much lower. So can you comment on this difference? So colleagues, who is ready to answer? So I'll start from the taxation. Within the digital economy program, there is a separate section on taxation where all the details pertaining to IP product taxation are described. And as it was mentioned today, expert community are open to your suggestions. If you think that there is a need to perfect this part of our taxation legislation, we are open, but let's do it in a non-linear way. For instance, when you say, well, the tax is 3% in the US, let's sort of stick to this percentage. If you can justify such a solution, then we are ready to listen to your suggestion. So the Ministry of Finance has been looking into this issue, and now they're working on a draft law on IP taxation, and this draft law will be placed on the Skolkovo website, and you can check it. When it comes down to capitalization, so the main aim of all digital platforms is the monetization, capitalization of the rights, IP rights. Because today, having all the registries at hand, it is still difficult to find the necessary information, trustworthy information, and we always question ourselves the IP rights, that we find in these registries. And switching over to blockchain platforms will allow all of us to speed up the search, to have more trustworthy information for concluding contracts and transfers. So I would like just to add a few words to question number one. So we are working on a program that will allow us to speed up the commercialization, to commercialize any IP product faster, to protect your IP rights, to place the information in one of the blockchain-based registries, and any owner will have the right to decide who to provide access, whom to give access to their IP product, IP property. And you can advertise it on the platform. You can place it in any format, in written format, in YouTube, visual format, music format. And what Artem said, and I cannot but add, this another very important task for all of us is to protect your IP rights on the internet. And again, I'm repeating myself, we are speaking about all formats, music, texts, audiovisual products, and we have to offer a comprehensive protection. We have to find a reference product to compare new products with. And for instance, when we speak about soundtracks, melodies, we have to find melody, a reference point melody or part of melody, a fragment of melody that could be identified in, say, DJ tracks. And when we speak about texts could be compared to a reference pattern, not only which are not whole text, but fragments of text, word collocations, and so on and so forth. So it's a complex task which will allow us not only to create, but also to commercialize the results of our intellectual activity.
So the copyright protects the form but not the content, because as soon as we start comparing the content, then we will get stuck in the court trying to prove who the author is, and then the situation will turn absurd. But of course we are not going to do that, but we have to move on and we have to enter some new stages in IP protection. And of course, it's our task to show to the, just to the author and to the writer, to show where the object is and how to protect it. I would like to clarify the same issue. So we go on telling that music films. So is it only about copyright and related rights, but is it also about industrial rights? No, of course, it goes much wider. It's not only about music and literary works. It's the industrial protection, industrial intellectual rights, and 3D models, and just some other things which are produced by the industries. Yeah, I would like to add that the key problem in this market is to understand who we buy from. Do we buy from the right person? And then I hope that there will be one register, one ledger, just like the Congress Library from the USA, so where we can fix who the author is, who the right holder is. So because of course this ownership has both negative and positive sides. As soon as we don't have a unified single ledger or register, that's difficult to prove who the author is, or who the author is, or who isn't the author. So I hope we will very soon see the ledger, and it will be trustworthy, and we will comply with Berlin Convention. So, and then we will have the same principle. If you want to create, just go and do that. If you want to register it, to patent it, go and do that. And then everyone will know that you are the author. Of course, it can be it can be questioned, it can be claimed, but so then we will have the legal sphere, the legal space where we can discuss it. So 2 more questions and that's it. Yeah. So it's such an advantage to be physical, close to the microphone. Vladimir Entin, the Center for Legal Protection for the IP. I have got a number of questions. The first is competition of jurisdictions, the competition of ledgers. I will clarify the second one. SSM, a reputable agency on right management, has got a very good technology on identifying the melodies, identifying the tunes, and according to that, it distributes the rights. And I was really very surprised to know, because I paid much effort to change the situation when all the composers of 40s and 50s, so whose works were protected, highly protected, but suddenly these works became classified as folklore. Then the second thing is how we can introduce the changes in blockchain when the original data, original information is incorrect. What could be the legal mechanisms of introducing amendments to the information information which originally was incorrect. As for the just as for the reliability of the information in blockchain, well, actually now you cannot delete the information if it is incorrect, but you can rewrite the whole block of information. And then, so the information will be highlighted. You can see the whole chain of information for the whole time that it has existed in the system. So then, well, I think it's quite transparent. So you don't correct the information, you just reintroduce it. What about the competition of jurisdictions? When it comes to the competition of jurisdictions, we don't plan any radical changes. If you are interested where the rights get registered, and if it is possible to apply to another jurisdiction or to apply to another system of intellectual property rights protection. So it much depends on where originally your rights were registered. And I think that our current legislation, which supports the whole federal system of IP protection, and then I think that this legislation is going to be the background for the whole system. Well, just blockchain system included. And then when the situation develops, we will see how the other jurisdictions regulate this. So we will acquire their experience because, well, just we can use the global principle of protection. So then, and I think that, so this segment will also be affected by globalization. Thank you.
Oleg Vashenko, holding Schwabe. I have two questions. The first question, copyright has been active for 70 years. If you make a very good system, all the people, all the heirs will come to you. The second question, do you understand that? The second question, Maxim, you said that I'd like to say that all the industry is going on around not intellectual property, but they on documentation. They work on documentation. If we move to 3D documentation, then we have some problems. What do you think? How your system will protect this documentation? These are two questions. As far as I understand, the question is about the objects which are not new but old objects. How will they include into the system? They are in the system at the moment, so nothing will change. The heirs will come, let them come. They today come for copyright fees or deductions and royalties. Nothing has changed. The another point is that the author died 70 years ago, but this is not a new problem. This problem is solved in the same way all over the world, all around the world. So I don't see any problem here. But probably there'll be some problem with folklore, and it's the same about these authorless, about forgotten authors. So, but these issues are solved in ordinary legal mechanisms. And the second question is a bit more interested. The point is that we are talking about the IP rights ledgers. Know-how ledger cannot exist because of the specificity of the nature of know-how. Know-how exists until it is secret. A ledger prescribes some public component. So if we speak about know-how, it cannot be protected within the public segment in legal terms, because as soon as you publish something, so you lose the priority. If we speak about the elements of industrial property, speaking about patents, That's about 25 years. The design, as for the designing documentation, we can call it a copyright, and it can be protected. But in this case, you cannot copy it, but you can copy the main ideas which are in the basis of this. So, but as for blockchain, it doesn't matter what you keep in a blockchain. I would also like to remind that designing documentation is not on paper nowadays. It is on digital form, and it is absolutely under the copyright legislation. I would also like to comment on this. I solve such tasks for commercial players in the market. I understand what you are talking about. You want to say that you have a solution without revealing yourself. The blockchain provides you with such an opportunity that you can describe some solution without revealing it. For example, the way of modeling a certain device, the way of organization of a device work. It's no problem at all. You will not be asked to reveal this information. But as for designing documentation, the work it is protected as a complicated object. There are texts, there are schemes, drawings, which are a separate objects of copyright. There are algorithms which are under know-how. So, and when we make this kind of documentation, if there are elements which should be protected by know-how, it is possible to do that in the system. It's a legal question. If you do everything in as a program, this is not a problem at all. It's just a digital form of supplying the information, and it's up to you. It's up to you. You can inform without revealing different secrets. So I guess we will have a chance to ask different questions and discuss them during coffee breaks. Let's thank our speakers for this interesting session. Thank you very much for your questions. So now we move on. Thank you.